Okay, and this is confirmation that our communication is successful. Our webinar relates to industrial designs in Russia. There are two parts. The first part will be conducted by me, Aleksander Vasilets, and the second part will be conducted by my colleague, Sergey Medvedev. So, first of all, the first item is the scope of protection of industrial design patent in Russia. I would like to begin with the legal basis of industrial design protection in Russia. Legal basis includes Part 4 of Russian Civil Code, which covers not only industrial designs, but also inventions, utility models, and trademarks. Rules for preparing and filing an examination of industrial design application, Locarno Agreement on classification of industrial designs, and Paris Convention on protection of industrial property. This year, Russia is going to join the Hague Agreement for International Registration of Industrial Designs, its Geneva Act, and so the legal basis will be wider. Here are some reasons why industrial design should be patented in Russia. First of all, it is obtaining of an exclusive right to industrial design. No one can copy patented industrial design without written permission of the patent owner. Possibility to sell licenses and access to the latest achievements in the field of industrial designs thanks to the research conducted by Patent Office. During substantive examination, the examiner finds prior arts, and these prior arts are directed to the applicant. So the applicant can be aware what happens in the field of designs. External appearance of great variety of articles can be protected as industrial design. However, there are some exceptions, and these exceptions are shown on the screen. Solutions which are contrary to public interests, principles of humanity and morality. Solutions which are determined exclusively by technical function of the article. And solutions which are able to mislead any user as to the manufacturer of the article and the place of manufacture. For example, if industrial design contains trademark of another party, then such industrial design can mislead the user as to the manufacturer and the place of manufacture. Scope of protection is defined by a combination of essential features which are shown in the presentations of industrial design. This definition is given in the Part 4 of Civil Code. You may see that only representations define the scope of protection. Although design application must contain description, but description does not play any role in defining the scope of protection. Description is used only for examination purposes. Industrial design is considered to be used in an article if the article reproduces all the essential features of design or combination of essential features which create the same overall impression on the informed consumer. In this definition, the notion of informed consumer is used, and this notion will be explained in a detailed way by my colleague in the second part of our webinar. In case of complex articles, such as automobiles, for example, in order to make the protection broader, it's recommendable to file applications not only for the whole article, for the whole automobile, but also for independent part of articles. For example, for bumper, for headlight, dashboard, rear lamp. In such a way, the patent owner will obtain the broadest possible scope of protection. Dashed lines can be used also to widen scope of protection. You see two examples of keyboard. In the upper example, the base portion of keyboard is shown by dashed lines. It means that base portion is not protected by industrial design patent because the protection is given only to those parts and elements which are shown by solid lines. In the second example, you may see that two columns of buttons and the trapezoid cutout are shown by solid lines. It means that the protection is given only to these elements. Other portions of keyboard are not protected. So by using dashed lines, the applicant receives an effective instrument to regulate the scope of protection. Representations of the article. As I have said, the representations define the scope of protection. That's why it's very important to submit such representations which give a full perception of the essential features of the article. According to our legislation, the number of representations may not exceed 7 views. If the applicant submits a greater number of views, official action can be issued with requirement to cancel some views. Perspective view may be included in the application, but it's not obligatory. If a representation of article includes the date of establishment or medals, then the applicant is obliged to submit documents confirming that the enterprise was established at the particular date and that the applicant has right for medals. Otherwise, such representations will be regarded as misleading. It's not allowed to use trademarks of another party in representations of industrial design. You may see on the screen the refrigerator, and in an upper part of the front side there is an inscription Bosch. The applicant of design application is BSH Bosch & Siemens Hausgeräte GmbH. But trademark Bosch is registered in Russia in the name of Robert Bosch GmbH. According to our legislation, the applicant of industrial design application and the trademark owner must be identical. In this case, official action was issued by Patent Office. And as a response to official action, the applicant submitted new set of representations without inscription Bosch. It was possible because the inscription Bosch does not play an important role in formation of visual image of article. Unity requirement. This unity requirement describes what one industrial application can contain. One industrial application can comprise one industrial design, set of articles, variants. A whole article and the independent part of it cannot be included in one design application. Here is an example of washing machine, a control panel, which is independent part of this washing machine, and a door, which is also independent part of this washing machine. At present, these three articles cannot be combined in one industrial design application, and in order to obtain protection, it's necessary to file three separate design applications. Here are three examples of variants. In the left part, you may see two flacons, which distinguish from each other in proportions. Difference in proportions is acceptable as a distinguishing feature between variants. Another example shows container for washing products, and the difference between variants resides in combination of colors. And the third example shows two dryers, and the difference between variants resides in the location of elements of intermediate rows. They are differently displaced with respect to the elements of central row. It should be pointed out that patent granted for design of real article, for example, of real car, is not valid for toys, imitating the same real article. In order to prevent an unauthorized production of toys imitating the real article, it's necessary to file a separate application. In this particular case, it's necessary to file one application for real car in Locarno class 1208 and the separate application for a toy car in Locarno class 2101. Examination of industrial design application. Examination includes two stages, the formal examination and substantive examination. Formal examination includes verification of such characteristics as completeness and correctness of application materials, relationship of the claimed industrial design to the solutions which are patentable as industrial design, correctness of classification, fulfillment of unit requirement, and correspondence of the filing fee to the established value. If any of these requirements are not fulfilled, then official Patent Office issues official action, and the term for response to such an official action is 3 months from the date of its issuance, with possibility of extension for not more than 10 months. Substantive examination starts automatically after positive result of formal examination. And during substantive examination, the examiner verifies establishment of convention priority and verification of compliance with patentability criteria. There are two patentability criteria in Russian Federation. The first is novelty and the second is originality. You may see on the screen definition of novelty criterion. Industrial design is new if combination of essential features thereof shown in representations of the outer appearance of the article is not known from the information that became generally available in the world before the priority date of industrial design. It means that any disclosure of information in the world made before the priority date can destroy the novelty. It should be pointed out that there is 12 months novelty grace period in Russia. It means that a disclosure made by applicant, by the author, or by any person who receives the information from them will not be taken into account during examination of industrial design application. This block scheme shows how verification of industrial design novelty takes place in the Russian Patent Office. For example, a design with features A, B, C, D is claimed. The examiner conducts a search of prior art. If the claimed industrial design is different from the closest prior art even by one feature E, then the claimed industrial design is new. If the examiner finds a prior art which is identical, in other words, which is characterized by the same features A, B, C, D, E, or having additional features F and G, then the claimed industrial design is not new. This example shows industrial design rejected as not satisfying the novelty criterion. The claimed industrial design is the out appearance of electronic device. The examiner found citation shown in the right part which has the same essential features as the claimed design. And the conclusion was made that the claimed industrial design is not new. Originality criterion. Industrial design is original if essential features thereof are determined by the creative nature of specificities of the article, in particular if a similar design is not known, which produces on the informed consumer the same impression. Originality criterion is similar to individual character, which is used in European community. You may see on the screen an example of industrial design rejected as not satisfying originality criterion. In the left part, you may see claimed industrial design. which is icon of graphical user interface, and in the right part you may see citation found by the examiner. In spite of some differences in the form of cutout in the lower part and in roundings of the roof, the overall impression which is produced by the claimed design and the overall impression produced by citation are the same. And the conclusion was made then that the claimed industrial design is not original. This block scheme shows how verification of industrial design originality takes place in the Russian Patent Office. The claimed industrial design is characterized by features A, B, C, D, E. The clause of prior art is characterized by features A, B, C. The examiner conducts a search for prior art with features D and E. If prior arts with features D and E is not found, then the claimed industrial design is original. If the examiner finds one prior art or two prior arts with features D and E, then a claimed design is not original. You may see on the screen an example of ID, industrial design, rejected as not satisfying originality criterion. In the left part, you may see a claimed industrial design, which is graphical user interface. And in the right part, there is citation that closes prior art. In the left upper area of the claimed design, there are several elements which are different with respect to the citation. But during examination, the examiner found citations 2, 3, 4, 5, 6, and the combination of these citations is characterized by the same elements which are distinguished with respect to the closest prior art. This example shows clearly that the examiner can cite not only one citation but several citations in order to prove that the claimed industrial design is not original. Now I pass the word to my colleague, and we'll make now a short pause.
Good day, everyone. Hello, everyone. Let me please continue the speech from Aleksander and start my presentation with the dual protection, because sometimes designs overlap with other IP rights, and the brand owner or design owner will have all options to choose and will able to enforce depending on the concrete circumstances. So the question would be, will the can a design be concurrently enforced and protected for the patented as well as copyrighted subject matter? Because usually the author of the design will be the first owner of the copyright, and the copyright subsists immediately when the work is created. So the reply would be yes. Russian law and practice allows dual protection for designs and for copyrights. So it is possible theoretically to file a copyright infringement suit as well as design suit with a court. Of course, you have to choose depending on the circumstances, and you have to pick up the right evidence, because for copyright infringement it may be one set of evidence, while for patents may be the other. And with all these circumstances and documents, we need to assess where and how to file. Then I need to mention that sometimes even triple protection would arise, because trademarks, like figurative marks, for example, would also contain a design. And in this connection, the design can be simultaneously protected as the figurative mark, trademark if it is registered, as an industrial design, as a patent, and also as a copyrighted subject matter. The question would be, what about if patent coverage lapse and terminate? Will the other rights lapse immediately? For example, will the copyrights vested in the design lapse, and will the trademark registration expire? The question is no, because as I mentioned, they are concurrent and they are separated subject matters and rights. So in this connection, the termination of patent protection will not affect the trademark protection as well as copyright protection. So even with the expiration of patent protection, the brand owner or design owner will have the right to enforce its copyrights and trademarks. Importantly, we have to remember that when there is a copyright and the company, for example, to whom the rights were given, want to file and register the trademark, the consent of the copyright owner needs to be obtained for the purpose of registration. And furthermore, if the same company wants to protect its design under patent and design law, they will need to obtain consent from the copyright owner as well as the trademark owner, because by the time they file the design, the trademark registration has already been granted, for example. And a regular, for example, label of a bottle can be theoretically protected again as industrial design, as copyrighted subject matter and trademark, and you will have to consider all these features when you manage your IP portfolio. Now we'll discuss the concept of the informed user, because this is kind of a new concept for the Russian law, which was taken basically from the international, basically European practice. And let me start from this slide. There are two basic statutory documents which will govern the concept of informed user. First, you want to see the recommendations on the issues of examinations of design applications, which are dated 2009, and you can see that during the examination, the overall impression of the informed user will be usually compared with the overall impressions which is produced which is produced from the analogous line of designs. So the examiner will usually comparing these impressions to make a decision on the grant of the patent. Also, it is important to consider the section 75 or paragraph 1 of the rules on drafting, filing and consideration of design applications, which are relatively new because they were amended in 2016. And here you can see that certain features on the informed user were taken from the European concept of informed user, and we can apply them here in Russia on the basis of that European experience. So they would define the informed user as the hypothetical person that will be using the article and is interested in using the same, and in which consequently is aware which features would usually appear in the design or analogous line of design when they will be applying this product or article. So basically, the concept is, as I mentioned, is inherited from the European one. Here are some, to make this clear, here are some examples, again, which we were able to find from the international practice, but the same opinions can be applied by the judges in Russia. For example, in a case related to game pieces or weavings, as we call them, the children and marketeers who were interested in promoting these game pieces were regarded as informed users. In another case related to designs of oil cans, the professional vendors were considered as informed users. So basically it's the seller of the goods, not the manufacturer, of course, that can be recognized as informed user. In another case related to handbags, the women were regarded as informed users because usually handbags would be taken and would be applied by women from around the world. So this is obvious, and the same approach can be used in Russia. And there was another case that we were reviewing recently regarding infringement of design protected for dolls. And in this case, the court considered children at their ages of 7 to 10, not children but girls, who were usually using this or applying these products during their childhood. So this is obvious that they may be regarded as informed customers. I'm sorry, users. To sum up, I can tell that the informed user under Russian law and practice would be someone in between the regular consumer and expert in the concrete state of the art area, and it can be a person that is a seller, is a marketer, or is a vendor, but not the expert or the manufacturer or even the designer of the goods. And also it can be a person who has obviously some knowledge of analogous line of designs, and he should be familiar with that so that affect the results of the case. The next reasonable question would be what would be the acceptable pieces of evidence when we show them to court? Well, the first would be the results of survey or public opinion polls, which we usually used to produce and to submit before the court, because you can engage a special social organization, and they will conduct this survey through a particular people, informed users who can vote for similarity of the designs during the infringement case. Also, some specific letters concerning similarity can be granted by the consumers, so by the vendors or sellers of the goods, and these letters can also play a good and favorable role in the enforcement action, because they will say that these people can be confused by choosing this particular design and not the brand one or so. So it's very important to collect such letters in the infringement case. Sometimes people would argue, and lawyers would argue, what about experts' opinions and determinations? In our personal opinion, this may not always be an informed user again, because this is, as I mentioned, a person who is someone in between the state-of-the-art person and the regular consumer. So that's why it is informed. That's why we wouldn't recommend to rely only on the expert determination or opinion in design infringement actions. We would usually suggest to use them in support of the other, for example, these two above documents, and the expert opinion will concern just the similarity designs, but not the overall impression which is produced on the informed user. The next topic would be the current enforcement and litigation practice, where I would like to share some views and situation on enforcement strategies regarding industrial design patents. First of all, we need to understand what is considered to be the use of the industrial design patent. As in accordance with Article 1358, Section 3 of the Russian Civil Code, the industrial design is considered to be used if in the article which contains all essential features of the industrial design, or a combination of features that produce the same overall impression on the informed customer, like the patented design, provided, and it is very important that these articles have the same function. Sometimes the articles or products may have different functions, and in this case it may be a dispute whether the use of the patent takes place or not. So the obvious and apparent situation would be in terms of infringement patent, and what would be the infringement patent according to Russian law. Infringement of the design will be the import, manufacture, use, sale, or offering for sale or marketing of the article, of an article which has the same function as the patented article, or which contains all the essential features of the patented article. The question would be where we can find the essential features. The essential features may be depicted on the images or representations of the article, which Aleksander already mentioned, and we can just compare them one by one. If this doesn't take place, it doesn't mean that there is no infringement, because the law now protects the similarity of designs, and basically if there is a combination of features which produce the same overall impression on the informed user as in the patented design, then we can talk about design infringement as well. For example, if the color is not the essential feature and we compare black with white, the informed user can say that the infringement takes place and we can prevail in the action. The general enforcement strategies are provided on this slide, and of course we wouldn't recommend choosing like one by one or taking just the one strategy as shown on this slide. We usually recommend to review all circumstances on the particular case and choose the appropriate enforcement option, because sometimes one enforcement strategy doesn't work while the other will work. The principal rule is if you want to sue the company or the individual entrepreneur in court, you have to serve a cease and desist letter in advance. In other words, the pre-trial action would be imperative for commencement of the civil action. This is a new rule for us, and it was just launched in June of the previous year, because previously or in the past we didn't have such imperative and we could start an action immediately without serving any letter of claim. But this is, I think, the international practice which we usually apply here in Russia, and because warning letters, letters of claims are very popular abroad, we use them also, and they are now mandatory in Russia. Sometimes there are large-scale infringements or infringements which are hidden, or the infringers hide the counterfeiting products or manufacturing facilities. In this case, we would recommend engaging the police so that they can organize the police raid and seize the counterfeit products. So this can be an immediate action, which can be very helpful. The other example of this, the same approach may be the exhibition or trade, which has a certain period, which lasts a certain period of time, for example, 2 or 3 days, and it's unreasonable to file an action because by the time the judge issues the decision, the counterfeit goods will already be removed. So for such type of situations, we usually recommend engaging the police to organize and to conduct raids and start an administrative or even criminal action, which can lead to a big fine and to imprisonment if a group of persons which are considered to be infringers are involved. And of course, there is an unfair competition doctrine which is protected in Russia as well as the other types of IP, and that's why imitations, lookalike products which use similar designs, like the designs which are protected as industrial designs patents, they can be also, these rules can also be applied to fight against such imitations and lookalikes. These cases are usually taken by Federal Anti-Monopoly Service or their territorial divisions, and they have this special quasi-judicial administrative procedure, which again is taken before Federal Anti-Monopoly Service or territorial division, and sometimes these actions are very helpful because these agencies, they help to collect evidence, for example, or by organizing public polls via internet and by helping collecting other evidence without doing it on your own. So sometimes it may be a very effective measure. Speaking about legal remedies, if we decide to bring a lawsuit and to file a direct case with the court, then this arsenal of remedies is available. You can claim recognition of right, for example, in case in reply to a cease and desist letter you receive a reply from the infringer that your patent is not protected, that we don't believe your patent is protected, so they deny the existence of patent rights. You can have a perfect cause of action for recognition of rights. This concept is similar to declaratory judgment, which the US law usually apply, but in favor of the plaintiff, the design holder, not the defendant. It is not possible under Russian law to bring the declaratory judgment for the defendant, for the infringer. We have only this action available for the plaintiff, for the design owner, which is of course very efficient for the brand and design owners. Also, we have permanent and preliminary injunctions, which are very, very popular kind of remedy in this type of actions. Speaking about permanent injunctions, they are very rare to be granted by the Russian courts because they would prefer to hear the case and understand all circumstances surrounding the same before issuing any restraining orders right away. So they would usually deny the motions on preliminary injunction, and it would be also very difficult to appeal such court ruling in a higher instance court. So usually design holders would rely on permanent injunction, which can be obtained as a result of the positive court action. Speaking about monetary relief, the Russian law allows to claim damages as well as monetary compensation. Monetary compensation is equivalent to statutory damages, and the advantage of monetary compensation over regular damages is that they are defined explicitly by law, and the only thing you have to prove is the fact of the occurred infringement. For the damages, it's not the case because you have to prove the fact of infringement committed by the defendant. You have to show the method of calculation by disclosing financial and other sensitive documentation, and also we have to demonstrate the court the nexus between these damages which you have calculated and the illegal activities of the infringer, which is usually very, very difficult to prove. So we would advise our clients to use just the statutory damages options, which I will show you the next slide. I mean the formulas, how you can calculate it, and use this effective and monetary remedies available. Also, there is a possibility to publish the infringement case in the official bulletin of gross patent. This is provided by the law that you can claim the publication of quarter, and what is nice that the infringer has to do it on its own, and he must pay for that at his own. So this is also can be of benefit to the design owner. So reverting back to the calculation of statutory damages or monetary compensation, basically you can claim something in between 10,000 rubles and 5 million rubles, or you can claim double cost of license or authorized use. For example, sometimes there are registered design licenses, and you can extract the value and the amount of such royalty and multiply the amount by 2, and you can also claim this. Otherwise, you can just calculate the general quantity of the counterfeit goods seized, and also claim something in between 10,000 rubles and 5 million rubles. Of course, it's not always easy to prosecute design enforcement strategy and take good infringement action. In many situations, the infringers would hire lawyers too, and they would apply different defenses and defensive strategies. One of the most popular would be non-infringement, when they would provide their own surveys, their own expert opinions, their own letters from other third parties, saying that no, there is no copying, the designs are not similar, or there is no general impression on the informed user, etc., which would kind of mislead the court and makes it difficult to enforce the case. Also, sometimes they may invite different patent owners with different designs, with similar but different designs, and they would say that no, we are using this design under a license agreement, and maybe this license agreement is even registered, so which makes it even more difficult to protect the case. Sometimes there is an exhaustion of rights when the products with the litigious design has been imported to Russia by the authorized distributors, and because Russia protects the national exhaustion of rights for patents, the defendant would argue that our patent rights vested in the design has been expired because the first sale has already occurred. So we have to, when we do a test purchase for the products that we want to examine, first of all, we need to take the serial numbers or other details or requisites attributed to the product, and first of all confirm with business people that this wasn't the shipment or the package of products which were introduced into commerce, into Russian commerce, by the authorized distributors or licensees of ours. This is very important. And also one of the most popular would be the abuse of rights doctrine. It can be everything that can be at hand with the defendant. So the first that comes to my mind is, for example, non-payment of patent annuities, when they were not paid for like a year or even 2 or even 3, and you still have time to reinstate, but you have forgotten to do so. The other side may say, no, he's abusing because he doesn't want to abandon to maintain the patent rights in the design, and he's trying to enforce his patent. So his rights were abandoned. So abuse of rights strategy should also be considered, as well as limitation period, because in general the limitation period for all enforcement actions in Russia is 3 years, and if you come to this infringement in like 5 or 10 years, the defense say no, this is just not fair. Of course, in addition to the defensive strategies, the defendant would use the so-called counter-actions, and the counter-action is obvious, it's patent invalidity, and you have to take note that this is a separate procedure which is started with the Chamber of Patent Disputes, which is a division of Rospatent, and it's not taken in the same infringement action in court. It's a separate administrative procedure, and what is also important is that if you want to suspend proceedings in court, it's not possible, because the law doesn't provide for such an option. You have to struggle in both fights and try to win the invalidation action first, and then return back to the enforcement. Otherwise, it may be a case when you win the enforcement action, the defendant will appeal, you win the appeal, you come up to the Russian IP court, which is a second appeal option. You win the case, and during this period your patent is invalidated, and oh my God, you lose all these rights, and your rights as if they were not existent. So in this case, we seriously and highly recommend to concentrate on invalidation action, and before even attacking the infringer, we recommend reviewing the scope of patent and the strength of patent before suing, and of course invite patent attorneys like Aleksander, for example, to do this job for you before doing any patent infringement offensive strategy. And last question would be, what happens if the patent is validated and the court action is positive? I already touched this, but this happens that this leads the infringer to a right to review the case once again, because he has the right to appeal to the court which has rendered the decision on infringement, to reconsider everything from the very beginning, and if he doesn't object or challenge the invalidity, then you will lose the whole action. And also, if you already enforced the positive court action in an infringement action, for example, you already took all damages, you already seized all products, they will probably file a separate suit for damages, because the decision was not right, because the patent wasn't validated. So this slide shows how important it is always to take the validity and the scope of patents in advance of every further step in terms of enforcement. So thank you very much for being with us today, and Aleksander and me are ready to answer all your questions if you have them now. If you don't have them now, because we were kind of fast, because we were having only 45 minutes for such a big topic and very important topic, because designs is sometimes even more important than any other IP rights to protect and to enforce. So you might have such questions in future. So you can always contact us by emails, and we will always reply. So let's start with questions if you have them. So there is a question Is warning letter mandatory only for design or for all IP rights? Yes, the warning letter is mandatory for all IP rights, including trademarks, copyrights, designs, patents, and even software, because software infringements is becoming very popular in Russia. And what you should understand is that if you are suing a company or individual entrepreneur that is involved in business and this dispute is of commercial nature, then you have to serve a cease and desist letter. If you are suing an individual person or physical person in a regular patent dispute concerning, I don't know, for example, non-payment of employee compensation, or another case when you are suing a domain name owner, which is usually would be the private person and physical person, then you don't need to serve a letter, because this dispute will be followed and taken by the separate court branch, which is called general courts. It's not the commercial courts. And the warning letters are mandatory in terms of this commercial civil procedure court, not general jurisdiction courts. Another question is, to which extent does the court consider the description of the design upon determining the scope of protection, especially for designs granted without list of essential features, applications filed after January 2015? We have been reviewing the recent court practice, which is kind of not so, I would say, not so large scale, because designs are rarely infringed comparing to regular copyrights and trademarks, thanks to nature of protection of designs, maybe. But this is the case. What we were reviewing is that the court would usually apply the images that are usually describe the design. Also, they can the representations and the description of the design that is protected in the article can be also submitted, and the expert opinions in which the parties will vote will also be helpful, because they will be also talking about similarity of designs, not of the general confusion, but of the similarity. Can invalidation action be started based on warning letter? Can be started by a straw man. The invalidation action can be started only through an observation, or we call it cancellation motion, that is served directly to Rospatent, and this procedure is usually long-lasting, but right now there are serious talks and discussions and even amendments introduced to cut them down to 6 months, which would be, of course, of benefit to all parties, plaintiffs and defendants. And we hope that this procedure will be simplified. But again, no warning letters for invalidation actions, only separate cancellation applications served with the Chamber of Patent Disputes directly. Any other questions? If not, then I think we should wrap up, because the time is kind of coming to the end. So again, any further questions which may come up in the future, please do not hesitate to contact us by email. We will always respond, and we'll be happy to respond. So thank you again, once again, for being with us. Thank you for your time, and it's been a pleasure to serve you here in Russia. We look forward to working with you in the future. Thank you, and bye-bye.